All right, we're just waiting on Facebook. We're live everywhere except for Facebook. The little go live thing isn't going on yet. Freaking thing. Sometimes it takes a minute. Maybe because things changed. It's computing the issue or something.
The stories section on my phone app looks different now than it did. See that? It was just in circles. Now they're like big ass squares. Right. I didn't change that.
Well, did you know they might as well? I don't want to start the music until I can go live on Facebook. Sorry.
That is weird.
Why isn't it starting?
Facebook shut us down, man.
Okay. Now, Restream is saying unable to connect. All right, hold on a second. Stop. I mean, come on, Facebook. You dirty bastard. Let's see if it comes up. Waiting on the Facebook go live. There we go. We got it this time, guys.
Kirk is not an attorney. This is not legal advice. This is to be considered for educational purposes only.
Good evening again, folks, except for we've gotten through the technical difficulties and we're back up on Facebook and YouTube. We're trying this again. We're just going to do a 1 hour show again tonight. So we missed an hour. We're going to make the announcement here, I guess. John Gentry's We the People versus the 50 United States. We are trying to return all 50 United States back to the Republican form of government, as it is written in law per Article 4, Section 4 of the Constitution of the United States of America. We're not taking no for an answer. We are demanding reform. That is all political powers inherent in the people, all of it, not just a little bit of it, not some of it. That would be powers that are retained by the people per the 10th Amendment. So we are demanding reform. And what we're doing is we're going to do an audit of every single state's constitution, every single state code. So anything that is unconstitutional can be put into this petition. That's a writ, right?
Mm-hmm.
Writ of mandamus.
Either a writ of mandamus or a writ of attachment. We're working on, I'm personally working on multiple different kinds of writs right now. I'm working on a certiorari into the Florida Supreme Court about the events of Monday. And I'm going to talk more about that as we get into the show, but I'm going to let you want to go ahead, John, and start off with the briefing on the main project.
So I've been working with the Supreme Court.
Start off with
Jeff Atkins. He's the clerk in charge of admissions in the United States Supreme Court, and told him what I want to do. I'm not trying to hide this. What we're doing, we're coming in force. We're becoming tens of thousands of people strong in the Supreme Court. And he, initially he's like, yeah, we can talk. That is no problem. And I came back a couple weeks later, and I'm like, I got 5,000 people almost in the first 2 weeks. We're going to be coming tens of thousands of strong. So how do we present ourselves? The Supreme Court rules require you have to list the party to proceedings. And I was like, if I have 10,000 people, if I have 200,000 people, I'm going to have to bring a truck, man, especially with the 60-pound paper you require. And, is that what you want? Is that judicial efficacy? And he's like, I don't know. We've never had anything like that before. And I was like, well, that's the purpose of Rule 20, extraordinary writ. These are extraordinary times. We the people are deprived of our rights. And so we need extraordinary redress. And I told him, Jeff, why don't you go talk to your colleagues and see, if we can come up with a solution on how we do this. So the crux of this case, we're going to challenge unconstitutional laws that have been enacted to protect corruption. The states, many of them have set time bar on civil rights complaints, on civil complaints under federal statute. And the states can't do that. The states do not have authority to set time bar limitations on federal law. They just can't do that. And it's worth a question, to the United States Supreme Court. And there are many other laws, and working with Chris, I've learned so much from him about emoluments violations, and so many of the states have set up statute that say if you sue a judge and you lose, you got to pay his attorney fees. Well, that statute doesn't exist for everybody else in the state and in the country. And so that's an emolument. That's a special privilege granted.
An emolument violation.
Yeah.
Because emolument is a lawful payment of services. Okay.
Yeah.
So when that payment becomes unlawful, an unjust enrichment due to one's advantage, gain, or profit, you're not supposed to be making a profit. So, like a judge gets in there and trespasses the law, a judge is supposed to be an umpire calling balls and strikes. They're supposed to do the findings of facts. And those facts have to be presented by the parties, not the judge, right? So when the judge, so I'll give a perfect example of my own case here. I made the motion for dismissal for lack of jurisdiction for, one, I looked up the code that they were quoting, and I found actually Fernando Cook was amazing timing, gave me a case that showed back in 2000 that under protection orders, that code that they get their full faith and credit from was found to be unconstitutional because it violated the Commerce Clause and the fifth section of the 14th Amendment. So I made that argument. Okay. Now the judge says, oh, well, I have jurisdiction over here, here, and here. No, you don't have jurisdiction because you're just an umpire. The other party over there is supposed to.
And I'm going to tag in, right?
So when the judge does that, we can't pay the judge to act outside of his duties he's supposed to perform.
Right.
That is an unjust enrichment.
Well, even
he's acting like the prosecutor, like he's a party to the case. Or most common stuff that a lot of people deal with out there is child protective services, social services, making up lies. Hardwick versus Orange County of Orange and Vreeken case. Okay, anyone with any official with an IQ greater than room temperature in Alaska knows that you can't lie. Okay, how many of you have been subjected to lies in your case or know somebody's case that has been subjected to lies by social services? Okay.
Or any court official. Doesn't have to just be social services.
Right. And this is where we go to Article 6, Clause 3. Most people know, too, you know, this Constitution and the laws made pursuant thereof are the supreme law of the land, and the judges in every state shall be bound thereby. Okay? Anything in the Constitution or laws of a state to the contrary are notwithstanding. That kind of follows along with what we're doing with John Gentry's deal here.
Right.
But in Article 3, or Article 6, Clause 3, everyone from the legislative branch, judicial branch, executive branch shall be bound by oath or affirmation. Yeah. And even in my own Idaho code, you're a public servant. You're either an elected, and that goes back to Article 6, Clause 3. You're either an elected official or you're appointed into a position of public trust. That's it. You're an employee one way or the other. Doesn't matter. You're supposed to have an oath of office to uphold this right here.
Let me tag in on what you just said, Kirk. From page 433 in the Black's Law Dictionary, 10th edition. From Kangaroo Court from 1849 is when this was basically conceived. Here's the definition. A self-appointed tribunal or mock court in which the principles of law and justice are disregarded, perverted, or parodied. So what you just got done describing is a kangaroo court. Okay.
Yes, sir.
And I even went in beyond that in my, remember we talked about this, my citizen petition, my original citizen petition into the U.S. Congress, where I stated, let's see here, page 12, paragraph 10. When advocates' allegiances become suspect based on core concepts of law, this becomes a concern of consequence in and of itself. The relative subject matter of consequence becomes secondary with respect to facts and evidence. So what I did was I showed Congress that they're not even paying attention to the fiduciary duty, right? Where's that firmness and standing between defense counsel and their client? Because according to the preamble in the Constitution, the law is supposed to provide for the common defense. It says it right in the preamble. So when I pointed this out and showed inconsistencies, and not just in my own particular case, there were a multitude of cases where I showed this throughout this part of the project, where we actually got responses from federal judges, and the federal judges agreed. So one such example was a case where client paid counsel to represent her, and this guy wrote an legal argument that looked like something a kindergartner wrote. So then when we took him to court and sued him, he wrote this magnificent, eloquent theme, right? So I came in as a fiduciary and said, okay, yeah, this guy's great. He's fantastic, blah, blah, blah. Where was this aggressiveness? Where was this tenacity when it came time to represent my client, his former client? And the federal court went, son of a bitch. No, it's all in how you point it out. Because remember, I've said this once, I've said it a million times. Justice is blind, and the court and the people to whom you're speaking know nothing about you or your case. So you literally have to start from zero every time. So this is where it comes into less can be more. And the more these cases unfolded, I started to devise this judicial report, which took me almost a year to write. And they're still working on it, which is going to be where I'm going to go with this next. But I'll come back to kangaroo courts because that's relevant to what happened here on Monday. And again, it was one thing for me to say it. It was something else for me to prove it. So again, this is what happens when you when you get properly credentialed people running the helm, right?
Yeah.
You know, my standard joke is, you know, you walk into accounting or any other department in any corporation in anywhere USA, and you got people busy, they're doing their jobs, they're paying attention to detail. You walk into the legal department, it's like you walk into a kindergarten romper room where you got people making photocopies of their rear end on the copy machine and, you know, just not even paying attention to what the hell is going on.
Yeah, we had, just to make a point for the viewers out there, we had some technical difficulties starting out. I probably got put in Facebook jail because I shared too much. We weren't able to start on time. But if you guys have any questions about the project that we're working on in We the People, demanding a return to the Republican principles that this country was founded on, drop your questions in here, and we will try to answer them as we go along. But unless I see questions up there, we're just going to kind of roll with the show and do what we normally do.
So basically, what we wanted to do tonight, Kirk and I discussed it earlier, so we wanted to kind of go over the general premise of what this project is and how it got started. So what I'm going to do is I'm going to read you the preface of the initial judicial report. It's very short. It's very easy to read. The whole thing itself, the actual reporting is only 21 pages, and it's a real that's not 22 pages including the preface. So the rest of it's case precedent and the Declaration of Independence. All the stuff is an interesting read. You should know it, but the actual report is very easy to read and it's very easy to follow. So the following report is presented for review in good faith as a friend of the court under license number 443079 as a fiduciary practitioner consisting of 9,301 words on 39 pages, not including dicta and appendix sources. My license holds and is subject to the high standards consistent with other fiduciary practices of care, sense of fair play, and equal protections under the law. My work is presented to this court in efforts to assist the case presentations in working with the plaintiffs in these matters towards protecting the integrity of these proceedings, the court, and these plaintiffs in congruence, a task not undertaken lightly, as the very course of multiple lives will forever be altered. Therefore, the utmost care must remain as the standards of practice, right? Not theory, practice, to ensure the continuation, protection of the Constitution of the United States be interpreted as intended by the 56 men who constructed it. What may seem so rudimentary to so many when in consideration of basic equal protections and basic due process as it relates to this practice, in other words, the practice of law, are luxuries it has never been afforded. So, in other words, attorneys have never had a due process to follow. If you don't do, this is where the swamp starts, right? If you don't do what we want you to do, Mr. or Mrs. Attorney, we're going to pull your bar card, and there's not a damn thing you can do about it, right? So, to continue, the fact that it has become arrogant and hostile is a side effect of this type of exile, right? It is for this reason my personal choice of profession was outside of this area of service for years. That was until I received the knock on my door, which forever changed the course of my life and forced me into action for no other purpose than self-preservation in my own case. Like so many before, I had for the longest time given up and decided not to care. I then remembered this. But when a long train of abuses and usurpations, pursuing invariably the same object, evinces a design to reduce them under absolute despotism, it is their right, it is their duty. I inserted the word fiduciary in duty on that second part, to throw off such government and provide new guards for their future security. So when it comes to where your rights come from in law and how you claim those rights, okay, It's all there. So it just depends on, the context of what you're going to say. And of course, you're going to hear multiple, we're not accepting it, and this is going there, and this is not going anywhere. Well, watch the news and watch, what's that guy's name? Cohen? Trump's attorney, Cohen?
Let me jump in for a minute.
Mm-hmm.
Trey had a question. Are we addressing statute by statute or just in general? And
all of them.
She made another comment that there's some laws that she wants to challenge.
Mm-hmm.
So here's the thing about the laws that we're challenging. The laws that we want to challenge in this are the laws that support this broken system. So the first thing we need to do is get our foot in the door, and they're going to come back and they're going to say, well, you can't just randomly challenge laws. And there's like a boatload of them. And evidently, Trey, you've already found 6 of them in your state. They're all over the place. These unconstitutional statutes that the states have enacted. But we're going to go after the one that proves that they caused us harm because it granted them unconstitutional immunity and because they're granted special privilege to persons in public trust. And those privileges and those immunities caused us harm. It provided a right field for them to come in and violate our rights. That gets us in the door to the Supreme Court. Now, if there are other statutes, I encourage each individual state to say in their amicus briefs that get filed into this case, oh, here's this other crap that they did too that's unconstitutional. But in the main complaint, we're just going to have a little small section for each state, and we're going to say, Illinois Code annotated, this law is unconstitutional, here's why. Tennessee law, this TCA 292204 is unconstitutional, here's why. And, we got 40 pages to work with in the brief. So we got to keep it short and sweet and say, this law is unconstitutional, here's why. That's our cause of action. And that's what gets us in the door and gives us standing, because that is the primary jurisdiction. I've been reading about jurisdiction from the United States Supreme Court from a 1936 book. I go back in the history and look at the original intent of what that court was established for. And I'm going to hold them to what was set in place, 100 years ago. So Trey, I hope that answers.
Well, another thing too is like when I've been running through my code, and where I find they talk about like the Child Protective Act or the Protection Domestic Violence Act. It's all policy first, and the policy is made by Department of Health and Welfare. It's in the health section in Idaho Code Title 39. I'm sorry, but the Department of Health and Welfare doesn't have the power to make law. Then we go and says, oh, well, it's the policy of the state, the legislative branch does, and makes statutes based off of this policy. Now I take you back to November 16th with Jeff Sessions, which we did a breaking news video on this, which is what Christopher Hallett is holding up right now. Okay, prohibition on the use of guidance documents. That is policy. Policy, okay, we have to understand how our form of government works here. We, the people, consent to creating agencies. And I'll take you to Title 74, Ethics in Government. And that's Idaho Code Title 74, Section 201, which specifically says the people of the state of Idaho, in creating the instruments of government that serve them, us, they serve us, right? Do not yield their sovereignty to the agencies so created. That means when the legislative branch creates an agency, per the statute is the reason why it's created the agency, right? Well, then the governor appoints someone head of that agency, and then they create policy. Now, that policy and making that policy is only to apply to the agents of that agency only, and shall not have the force and effect of law. So to minimize the amount of pages we would definitely have just from one state, we could go with just, this is the policy. That voids all of those statutes because it's policy. So that whole entire chapter, because they go title, chapter, code, or statute. It's all code. And again, we go back to code as in Alpha, Bravo, Charlie, Delta, Echo, Foxtrot. Okay. That's military code for the alphabet. So
before we jump over to Chris here in a minute, you know, this fixes everything, I think, or it fixes a lot of it. You know, Kirk, does your Constitution guarantee a right to trial by jury?
Yes, sir, it does.
Mine does too. And our federal Constitution guarantees a right to trial by jury in matters exceeding $20, which is about $600 in today's dollars. We are deprived of that right, no doubt, and we are subjected to partial and biased courts who have corrupt interests. And the primary redress that we're going to ask for in We the People versus the 50 United States is that, you know, we don't want trial by jury in every case. We cannot do that to the people to pull them out of their jobs. That would be ridiculous. But
see, that's the thing. We should be doing that because the people ought to, you know, if you're getting pulled out of your job, you're getting pissed because you're getting pulled out of your job. Well, we're going to go ahead and just exercise our political power here called jury nullification to nullify that statute, that code that's supposed to be codifying or codifying the law. This is the law. Declaration of Independence is the law. If that were to start happening, we wouldn't be having people going to court. Yeah. That would stop.
Yeah. Right. Yeah, and this is one of the reasons, and we get into this, right? And it's one of the reasons why we want to teach you guys how to separate the difference between the law, okay, and what it says. What a rule.
Chris Marks, shall confers discretion. No, actually, you need to go read American jurisprudence. Shall means there is no discretion.
Yeah, no discretion. It is what it is.
May is the one that has discretion.
Right. Or could. Right? May, could, right? Might.
They use may or shall. Like Congress may regulate this.
Right, which means which
shall
means
not be infringed is a
shall means
shall. Shall is a direct I can't remember exact words it's in American jurisprudence, but it's in volume 16, section like 79 through 100 there. Mm-hmm. And I have it right here on this little USB stick.
So basically, remember, there's a difference between the law, which is not broken, right? I mean, the law doesn't break. It's the law, right? That's the that's the immovable object. This force, this thing that they're trying to create, that's what they think is an irresistible force. These guidance documents, right? What's a guidance document? What's a rule? What's a statute? And what the hell does it codify?
Mark.
So, for example, that document that Kirk was mentioning in his case, where that particular piece of legislation, whatever it was found unconstitutional, the court cannot claim good faith and credit. That's Owen versus City of Independence when they know they're breaking the law. So when Kirk brought to the court's attention that was an improper guidance document, remember these, right?
That actually was declared unconstitutional.
That means
it's not even a guidance document anymore. Well, again, now it's a guidance document because they went through Title 39, Health and Human Services.
Right. And that because it came from an agency, Okay. Because it comes from an agency, it is a guidance document, right?
Yep.
So here's one of the things I want to put out to everybody. Anybody who's ever worked in any kind of into a corporate structure, done any kind of policy review, you know what a policy document is, right? Myself, I've created in multiple versions of policy documents, okay? One of my favorite things is to say about this is they've rewritten their policy to reverse practice the law. The law is our instrument to limit government, right, and keep them small. There are factions out there. I'm not going to go into the political crap of it because I hate that, but they are literally reverse practicing it. So they've got it going backwards all the way back to you all the time, right? And in the meantime, as they're running around this shit show, they're bleeding emoluments right out from underneath you, right? That's where the money comes out. You owe this fee. You owe a fee here, a fine there, a fee here, a court cost over there. And it never ends, right? So here's the significance of pointing out exactly what the emoluments are, because if it's in government, it's an emolument, and that includes the seat that they sit in. That's called an inherited emolument, right? That position of authority that we granted them to take care of the affairs of the government, right? In other words, prevent foreign invasion. There's a good example of one. There's, let's see, make sure the infrastructure is taken care of properly. We got proper roads and bridges, proper water supply, et cetera, et cetera, et cetera. So those are the things that we've entrusted to manage. When we find out they're bleeding this stuff dry through these policy documents, right? Every time they write one of these or they run somebody through one of these, they're taking an emolument from it, and they can't do that, right? So when I went through and I pointed this out on Monday, this guy, let me just put it to you this way. This guy from Title IV, I think he was a D, Title IV D guy. This guy got so pissed he was like red, like the top of that pen red. I mean, it was absolutely so bizarre. I actually said, okay, you're going to do whatever it is you're going to do. You've already been informed you don't have jurisdiction to do what you're doing. I've already informed you this case is being litigated before Congress. You've been served notice. As of April 13th, 2018, they've even had the follow-up report, right? So when the judge closed the case back last year, I took it to Congress. Just because the court says no doesn't mean it ends. You've got 3 branches of government, right?
Exactly.
So,
yeah. And that's what we're doing with We the People, is we're exposing one branch of government for the truth that is there, and not the lie that they present to the people. So,
right.
You know, this case we're working on it's not the end game. This is all working. This is all working together.
Right.
Yeah. And see, what this really boils down to, back to kind of what Chris was talking about earlier, is bills of attainder. And I want to jump back to this again, because this is July 6, 1775. Mm-hmm. This is the Declaration for the Causes and Necessity for Taking Up Arms, but they're explaining what's going on here. And we're talking just a couple paragraphs into it here. Parliament was influenced to adopt the pernicious project, and assuming a new power over them, have, in the course of 11 years, okay, so 11 years, given such decisive specimens of the spirit and consequences attending this power as to leave no doubt concerning the effects of acquiescence under it. That means go ahead and allowing it to happen, okay? Mm-hmm. They have undertaken to give and grant our money without our consent, though we have ever exercised an exclusive right to dispose of our own property. Statutes have been passed for extending the jurisdiction of courts of admiralty and vice admiralty beyond their ancient limits, for depriving us of the accustomed and estimable privilege of trial by jury. Okay, this is where bills of attainder come from, and they knew what it was. But see, this is part of they didn't know who it was, who this ministerial enemy. They call it a ministerial enemy right here in the beginning. They didn't know. They're like, well, for so long we've been great with the king, the present charters. We even aided in helping with the war without bloodshed. Okay, everything was going really good back then. And just so you know, most people don't know this, but Jamestown, Virginia was established in 1603 with the first charter of Virginia by Sir James. So that was when the Magna Carta was brought over. So that's the common law of England, and that's why we still use the common law of England, is because the English people came over here to America.
Yeah, in the 12th,
and
12th,
they were
century.
leaving for, are you ready for this? For religious freedom.
The 12th century, we knew that judges could not be trusted and that we had to have juries. That was a big part of the Magna Carta and brought over
1166 with the Aziz.
And brought over in the Virginia Declaration of Rights. And that's something that I've learned from you, Kirk. And that's what we're going to be demanding back is our basic right to trial by jury.
Mm-hmm.
And that's what we're going to come together as a people. And no matter what your issue is with the government, whether it's child protective services, father's rights, medical kidnapping, doesn't matter. At least you got a fighting chance if you got a jury.
Well, we talk about the different scales and how they exist, right? What I'm showing you here is the version of the equity scale, which is a hanging scale that exists in law. I don't know if you guys can see that or not. See if I can get that a little closer, but can you see that all right? This is hanging scale, and you move your interest, right? John is an accountant. You've seen this before. You move your interest depending on how much stuff is on the pedestal. Depends on how much weight, right? In which direction you got to move this bad rascal, this way or this way, to keep it balanced, right? Well, what they have done when they created the family law court, they took and combined that scale with the criminal scale, which is the attornment, right? The attornment process. So when they make a false allegation against you and sever your contact, okay, your interest in the stuff, you end up way down here outside of the process, right? This scale doesn't even exist in law. This is family court right here. This is.
Well, it's not just family court, it's every court out there.
Hey, right, for the purposes of this argument, for the purposes of my case, this is the family court, right? And this is, like I said, you can choose. I tell everybody, choose your battles. I choose to talk about the stuff that is relevant to my situation. And because I was able to show that this doesn't exist in law, right? And, it's like I said, you can talk about whether it's the credentials, whether it's the way I went about it, call it whatever you want. Kind of the long and the short of this is we're already seeing the effects of this going away, because by the end of, 2019, Texas has already started the process of repealing family law. So, and here's the best part about that. Once the first domino falls, I'm going to read you a little something here from, as soon as I find it, here it is. It's called Article 4, Section 2, right? We talk about equal protections under the law. All right, let's talk about that. Article 4, Section 2. The citizens of each state shall be entitled to all privileges and immunities of citizens in the several states, right? So basically what that means is once one state falls, they're all done. And that's kind of the long and the short of, I don't know if anybody's read The Art of War or not, where you fight the enemy where they aren't, move like water, whatever. Moving like water is very simplistic in that water doesn't move on the top. Water movement is an undercurrent, right?
Let me get to the heart of the freaking problem here, and I'm gonna share my screen to do this. This is the heart of the problem. There is no doubt. There is no oversight of the judiciary. Can you see my screen? Okay, you guys.
Yep.
So I prepared this report specifically for Chris, and Chris submitted this report in the United States Congress. There's a 95.5% average, 96.5% median dismissal rate of complaints against judges. This is the problem right here, folks. There is no oversight of the judiciary. And what this means is that we do not have an enforceable right of due process. We complain about it and they dismiss it. We sue them in federal court. The federal judges support them, and they will not enforce constitutional statute that was legislated by our Congress back in the 70s and 80s doing 42 USC 1983 through 86. The judiciary has snubbed their nose at Congress, and Congress has transferred their power to the judiciary because nobody is enforcing federal law and nobody is enforcing the Constitution against the people who deprive us of our rights. This is the problem. If you scroll down here, I think, I'll just jump through this page real quick because it's going to jump right out at you.
But the thing is it's not just the judicial branch. It's the whole entire, it's all under this admiralty jurisdiction.
Right.
It's from the legislative branch to the executive branch to the judicial branch. It's
right.
All three branches are colluding together, and it's been infected with the bomb. Mostly right. The legislative branch and the judicial branch. So, somebody comes out there and becomes an attorney. They're not a lawyer. Okay. Let's get this cleared up and get rid of this calling them lawyers, because they're not lawyers. They're attorneys. They go to school to attorney the people. And then they grow up and they go into politics, or they go into the judicial branch. That's what they do. They run for public office, or they run in and they continue into the judicial branch. So that's how the judicial branch has been infected, because they went to school to learn how to attorney the people. And this is why they act like the prosecutor when they're up there on the bench in their black robe disguise in these star chambers, which is just what I just posted there. That's straight out of the annotated Constitution, folks.
Yep.
And it's funny, from the link that I posted there, this is actually under the Sixth Amendment, the right to a speedy trial part, and the right to a trial by jury part. The annotated Constitution is explaining the Sixth Amendment, is what I posted there. But you get down in there and it's like, well, we don't really know where the right to a trial by jury comes from. But in an upper part, you say, you know exactly where the right to a speedy trial comes from. And it comes from the Magna Carta. To no man will we sell nor deny or defer rights. Okay, that comes from the Magna Carta, chapter 40 of 1215 and subsequent revision of 1225, and into the Virginia Declaration of Rights, and then the Sixth Amendment. But when it comes to the right to a trial by jury, well, wait a minute. I've read this before, but it just blows my mind. Here's the Virginia, and then they say in there, oh, well, it's in the Constitution. First was in the Constitution. No, it wasn't the Constitution. It's the Virginia Declaration of Rights, the same place where the right to a speedy trial comes from. And it says that in all capital or criminal prosecution, a man has a right to demand the cause and nature of his accusation, to be confronted with the accusers and witnesses, to call for evidence in his favor, and to a speedy trial by an impartial jury of 12 men of his vicinage. This is the key part. Without whose unanimous consent he cannot be found guilty. That's the reason why they don't want us to know this right to the trial by jury and how it works.
And that's the main
unanimous consent to find you guilty, not a unanimous consent to find you not guilty.
And that's the main redress that we're seeking, and we the people, is a restoration of a right to a trial by jury. Look at this chart. Majority, and this is not my chart. This is a state judicial oversight agency. I believe this one is Kentucky. Look at the problems coming out of domestic relations court. How hard is it to not screw up the law, when you're dealing with family matters? And you look at the graph on this, look who's complaining. It's the litigants, because they're being subjected to mock trials. This is their report. I didn't come up with this. You can go download this off of any state court website. Let me show you guys one more real quick. I shared this in another show, but we've got some new viewers. This CNN did an article here, and this was on the federal courts. Same freaking story. CNN found very few cases against judges are deeply investigated. More than 1,000 complaints are filed annually. You don't know who did what. You don't know what the outcome was. In most years, they don't sanction a single judge. This was reported on CNN. This is the heart of the problem also. So we are deprived of right to trial by jury, and we can't enforce our right of due process because these judges cover for each other, and they will not hold themselves accountable. And that's in violation of the canons. It's in violation of ethical rules. It's in violation of our Constitution. They're snubbing their nose at Congress, saying, we don't have to enforce your rules. We interpret the rules, and we interpret the law, the statutes, the guidance documents, and we interpret it however the hell we want. And screw you, Congress. We don't care. Screw you, people. We don't care about your rights. We're the new aristocracy in this country, and we have the power, and there's nothing you can do about it. Well, we're going to go see what we can do about it with
yes, we are
in Congress and now in the United States Supreme Court, and we're going to see if we can back them up the ball and say enough taking children, enough extorting us, enough of these emoluments violations, enough depriving us of our rights. It's time to put this country back on the path, or this entire country is going to look like California, and it's going to be crap unemployment everywhere because you've destroyed all the high earners. You've destroyed all the families that contribute to the GDP of this country. So we'll see where the hell this goes. But coming together as a people and going to the Supreme Court, going to our Congress, I believe that we can change this thing. And I'm so grateful to the people that are standing up with me saying, yeah, I've had enough too.
Yeah. We need to have enough people basically to, basically just say, look, we're done. We're not doing this no more.
Yeah.
Shut it down and shut
we are done yesterday.
But we have to come together.
We'll see what they say.
We can't have one person over here in this state trying to fight in one county court over here and try to go to federal court and get your rights denied, because no attorney is going to effectively claim your rights and defend your rights in federal court. So you're stuck trying to do pro se litigant. And what's the failure rate? What's the dismissal rate over there? 97.6%.
Yep.
Yeah,
what are your chances of the federal court even accepting?
Let me correct you on that. that's complaints against judges with judicial oversight agencies. They dismiss 96.5%. In federal court, there's 100% dismissal rate of complaints against judges. Now, the part you just said about a pro se Surrey jurist, you know, I'm going to stand up for my rights and do it myself because these monopolistic, corrupt attorneys will not stand up for the Constitution because they know they're going to get disbarred the minute they stand up for somebody's right. The dismissal rate in federal court of pro se cases against legal professionals and judges, 100%. It has never happened. And if my case happens, it's going to be one of the first, if not the first. We'll see what happens.
Right. And you know, I mean, it's really up to us. Yeah, Don. We know about Title 18, subsection 242. That's, you know, deprivation of rights while acting under color of law. You know, we're talking about treason. That's a capital offense, capital felony treason. That's my point. You know, in writing.
That's my point in the Supreme Court. For them not to enforce the Constitution is treason against the Constitution. Justice Peckham, 1908, said that. You know, for us to take jurisdiction when we should not, or for us to abrogate jurisdiction when we should have taken it, the one or the other is treason against the Constitution. And I'm not going to hold, I've already said it. I already put it in the Supreme Court and said for you not to take this case, according to Justice Peckham, one of your 1908 predecessors, you're in treason against the Constitution.
Well, again, right back to declared act of tyranny, they have altered fundamentally our form of government. And that's again, right back to July 6, 1775. That's in this list here. And for altering fundamentally the form of government established by charter. We established by Constitution our form of government, and actually it's more the Declaration of Independence is the form of government, which is self-governed. That's why the people of Idaho do not yield their sovereignty to the agencies so created, because we are self-governed. That's why we're supposed to have a trial by a jury. That's why we're supposed to have suits at the common law per the 7th Amendment. It's because I take you to American Jurisprudence, Volume 15, Civil Rights, Section 2. Natural rights, civil rights have nothing to do with the establishment, which is the legislative branch, support, which would be, I don't know, the executive branch, or management, which is the judicial branch of government. They have nothing to do with government because that's the law. And I'll take you to American Jurisprudence, Volume 16, Constitutional Law, Section 100. Okay. Bills of rights, plural. Bills of rights are merely declaratory of the common law. So anyone who tries to tell you, which I basically burn people with this one right here. Oh, well, case law is the common law. Really? So how do we have a suit at case law? When was the Bill of Rights? When was that 7th Amendment made? What kind of case law did we have back then? Right.
Actually, that's actually contradictory, and here's why. Right? Case law is not law at all.
That's an stare decisis.
Right. Cases are examples of decisions that were made based on a set of circumstances in that particular matter, right? So there might be similarities in those matters, but there are also a myriad of differences, right? So that's one of the reasons why there's a maxim of law that states a precedent that solves one problem and creates another is actually, bad precedent, something to that effect. Anyway, it accomplishes nothing. That's what it says. But and that's one of the main important issues that we talk about when we refer to different versions of stare decisis. So
what it really boils down to is the judicial branch doesn't have the power to make law.
Correct.
Plain and simple.
They have the power to limit government, right? If it's required that they limit government. For example, take the Miranda versus Arizona decision, right? They had to limit law enforcement to make it required that they read you your Miranda rights, right? Tell you what your rights are when they take you into custody. If they don't Mirandize you, the arrest is invalid, right? It's done. It's gone. And they have to Mirandize you every time, which goes back to what didn't happen on Monday. And, that's why I said this is going to be an interesting little how we're going to handle a local bad actor. And I think that's actually what they want. So they want me to do here what we ended up having to do in Texas. They got a shit show going on up the road. And they know it's making it look bad because I told them, hey, you guys are in disrepute. You already know it.
Yep.
You've already agreed that you don't have jurisdiction to do what you're doing. So what the hell's going on with this little shit show? And they're like, well, if you're willing to do it, we're willing to make sure that it happens is basically kind of the short version of that.
If the stakes were not so high, I would be kind of having fun with this crap right now because these guys just step all over themselves,
every time.
They just step all over themselves and show how corrupt they are because they finally got a pro se litigant, sui juris litigant in there who knows the law, knows the rules, uses the rules, and says, what are you going to do? Are you going to follow them or not?
Well, and there's
they haven't had people like us stand up to them before, and they're kind of like, oh shit, what are we going to do now?
Right, and it goes down to something like this. From paragraph 1 of my judicial report, does not matter what the law intends if no one is practicing the law as it was written and intended, or even worse, intentionally misrepresenting the law based on the agenda of the ones who stand to benefit from it, right? So, that's the end of paragraph 1 of my judicial report. And the whole thing is written just like that. So
I got to tell you my ending in my petition for rehearing en banc. This is a precedent-setting error of such magnitude that it shakes the very foundations of American jurisprudence.
Right.
I just came right out and said it. Like, are you guys really gonna write this? Really?
Yeah.
You're gonna ignore the law. You're gonna ignore the facts, and you're gonna misapply federal rules of civil procedure? Really? Okay. Well, if you do, we can just toss out the law because it doesn't matter anymore, and let's just admit it. Let's just clear here that there's this new aristocracy that can do whatever the hell they want to us. Well,
right.
I'm not okay with that. I know you guys aren't okay with that. And evidently the 5,000 people that have joined We the People versus the 50 United States, they're not okay with it either.
Yeah.
We're going to stand up to these guys. We're done being bullied.
Yeah. Not going to happen. Not anymore. And, it seems so simple. What actually got me started in on this thing was, people talk about how they object to paying child support and this and that. And it was like, well, I never objected to that. What I objected to was, why the hell is the state government taking $8 out of every $10 to spend on whatever it wants? I wasn't married to what did they call it? The welfare state of Ohio. That's what they called it. Said, I was never married to the welfare state of Ohio. Who the hell are you to go take an $8 out of every $10 that I'm giving to provide for my kids for who cares what they want or what they need? It's none of anybody's business.
Yeah.
And because I started to fight that and I started to investigate it, which is, again, what I do, I literally fell face first into the emoluments clause and said, well, guess what? That's an emolument. You ain't getting it, period.
Chris, I want to turn you on to a question here because I think Chris, for the audience out there, Chris has been at this 28 years. he's seen all the crap that these guys got.
Yeah.
But I wanna do a plug for Jay, because I just noticed this. Jay Moss, far from normal radio show.
What's up, Jay Moss?
Yeah, Jay Moss just left a comment, and I want to share it. Love Jay Moss. Those guys are doing good stuff over there on their show. You guys, go check out Jay Moss. But listen to this comment. Abe Larton, running for Attorney General in New Mexico, will be on tomorrow evening on the Far From Normal radio show. We will address his views on abolishing Title IV. So I'm going to tune in for that. I hope the viewers on here will check out Jay Moss. Love it. Chris, here's a question in the feed from Cindy Bowers. It says, I have a question. We know that the social workers lied to take kids. Police report had a horrible felony on it to take kids. Today we got discovery. The police report is changed to a misdemeanor and lacks evidence. They said they had to take away kids. How is that going to play out?
That sounds like a repeat of the Hardwick case, doesn't it? Almost verbatim.
Yeah.
I mean, everybody's case is going to be the same. It's all about lies.
Yep.
It's all about policy. They're not following the law. Because right back to what I just said, American Jurisprudence, Volume 15, Civil Rights, Section 2.
Right.
Yeah.
Okay. Natural rights and civil rights have nothing to do with the establishment, support, or management of the government. They have usurped their powers that were delegated. We did not delegate the power to control the common law. They cannot change the fundamental law. Let me know when somebody can change 2 + 2 = 4, because that's a fundamental principle behind mathematics that dictate the correct answer. Just like 2 - 2 = 0. 2 divided by 2 = 1. 2 times 2 = 4. And if there's anybody out there that is not in reality, that doesn't understand, when I'm literally legal, lawful term there, understand, stand in agreement with those correct answers, you're insane. Yep. You are not in reality.
Chris, what's my new favorite legal maxim you told me the other day? False in one thing.
Oh, falsus in uno, falsus in omnibus. False in one thing, false in everything.
Yeah,
right?
Falsus in uno.
That goes back to Cindy's case about wrongful children. False in one thing, false in everything.
That's right. And then, we go into, for example, when they want to start using stuff against you in court. I was digging through some of my old college textbooks, found my old criminal evidence book. There is probably should have marked the page on here. There is there's also called a fruit of the poisonous tree doctrine. Okay. I'm going to read that fast. The principle that any evidence derived from a violation of a defendant's constitutional rights is inadmissible. Let me read that again. It's the principle that any evidence derived from a violation of a defendant's constitutional rights is inadmissible. So in other words, if they lied and admitted false evidence, that's fruit of the poisonous tree. Okay? That's also part of the exclusionary rule, which I'm going to go into as far as what you want to ask what law enforcement thinks of the exclusionary rule. I'm going to tell you, because this is a book written for law enforcement officers. And that's one of the reasons why I'm using it to do this. It's page 186. And I had fun with this one.
This kind of, while you're looking for that, Chris, there's another one that Chris turned me on to. I love the legal maxims, because that's a big part of the foundation of where we came from. Mm-hmm. Another one of my favorite, and I think it just kind of clicked in my head that this plays into more than just unconstitutional statutes, and it's act off the top of my head, actus repugnus non este produci. Repugnant acts should not come into being. Now, I was applying that to unconstitutional statute, but a repugnant act doesn't have to be just an unconstitutional statute. A repugnant act can be this crap that they're doing, you know?
Yeah, an action.
Yeah.
Right. Not necessarily a legislative act, a repugnant act, like I can arrest you without a warrant for a misdemeanor.
That
is a repugnant act.
Yeah.
Right.
Okay, because it can only be for a felony that's happening directly in front of you. And I don't care what disguise you're wearing, no man is above the law. So an arrest can be made by anyone at any time for a felony that is happening directly in front of you, or disturbing the peace. But then let's define disturbing the peace, because disturbing the peace isn't standing out on the corner yelling, not per se. Okay, that's not necessarily disturbing the peace. And nor is arrest, put handcuffs on you and take you to jail. So we have to understand what these words actually mean in law, what they mean, not what the government tries to tell us or what that man or woe man is trying to tell us. And so just so people understand here, when I say man, I say mankind, not as in male or female. Man is mankind. So I don't care what kind of disguise they're wearing. That doesn't give them any special authority nor special powers. I mean, we're not all Superman and Incredible Hulk or anything like that out here, okay? We're real people, real men and women. We are mankind. And no man is above the law.
Right. So
there's also the unwritten law in the spirit of the law. What do you got?
Let me finish because I found it. So I'm going to finish what the exclusionary rule says.
Yeah, go back, Chris.
The exclusionary rule is the rule of law that excludes from admission into evidence against an accused person any evidence obtained in violation of certain constitutional rights. Now, there's a myth and a fact about this. Here's the myth. The myth is a statement made by an accused after the accused's rights have been violated is inadmissible against the accused at trial. That's a myth. Here's the fact. Although the accused's statements made after the accused's rights have been violated are generally inadmissible under the exclusionary rule, such statements are admissible to impeach a defendant under certain circumstances. For example, such statements are admissible when the defendant testifies at trial and makes a statement inconsistent with one made after his or her rights were violated. So in other words, let's go into this with the, I'm going to bring this into full being right now because this is a current event. The current event of Robert Mueller trying to go after the president to make him sit down and answer this long list of ridiculous questions. What were you thinking? What were you feeling? You know, you can't ask anybody, let alone the president, for God's sake. What were you thinking and what were you feeling? What they're looking for is what Mueller's looking to do is he's looking to entrap him into committing perjury. And the definition of perjury they want to use against the president is, hey, you said this here, and I perceived it as the investigator to mean this. Now you say this, and I, as the investigator, perceive it to mean something else. And here's the problem with that. The only person that has that discretion is Robert Mueller himself. That's the problem, right? Because what that does, is exactly what they've been trying to do to every one of us, right? Well, you said this and this and this, and yes, it may be based on the same fact, but because you didn't use the exact same verbiage, right? It must be a lie. It must be perjury. Now, no reasonable person would conclude that your state of mind at the time of an incident is the same as your state of mind after the fact, which is also part of the exclusionary rule itself.
Sorry.
So,
but a judge will go ahead and say, oh, yeah, that's perjury, you know, because they're going to play right along with the crap game.
And that's a problem because we're talking about, and this is where I talked about this monopolized prosecutorial discretion. Well, wait a minute. The fact doesn't change. I don't care what your perception is. Your perception has nothing to do with the fact, right? So just because my assessment is different than yours does not constitute perjury, right? And I also discovered this. I saw them potentially starting to be able to use this against my kid's mother. The more I put this together, the more that's why one of the reasons I dug these books out, because I'm like, hey, wait a minute, I've seen this shit show before. I remember I studied to learn how to do that job. So I know the trick, right? I was taught how to do that. And so because I remembered that, I said, hey, wait a minute, that's potential entrapment. And in every state, every, every municipality, whatever, they have a law or a code or whatever that prohibits entrapment, because that's exactly what that is. It's entrapment. And
talking about this, I'm going to go just like total sidebar here on that entrapment issue.
Mm-hmm.
So what's the favorite thing they have when you speak out about the injustice that you've been dealt with through these mock trials? Contempt, you're in contempt of court, shut down your Facebook. You can't say bad things about the judge.
Are you talking about gag orders?
Well, you've seen it on divorce court. A guy went out and said, this judge is being totally unfair to me. And then they, under threat of duress of incarceration, they force an apology. They force you to retract. They tell you, you can't speak your mind about the unfairness that you're being subjected to. If our rights weren't being violated, if we weren't being denied justice, we wouldn't be talking bad about them. And in my mind, the definition of entrapment is causing somebody to do something that they normally wouldn't do. Actually, I think that's kind of Black's Law Dictionary definition of entrapment is causing somebody to commit a crime that they normally wouldn't commit. And so,
right. That's the difference between the theory and the practice. Remember, the Black's Law Dictionary is the theory, right? This book is the practice. And this is where I talk about and where a lot of people get confused. What the law says doesn't matter if nobody's practicing it as it's written and intended. And this is where myself as a practitioner, same thing with you, John, this is the realm we live in. We live in the practice. We studied the theory, right? We got tests. We took tests on it. I just read it over and over again.
Here's the other crap they do. Like, okay, I think I would agree that you two gentlemen know the law pretty well.
Mm-hmm.
I think I know the law pretty good. I made it all the way to the United States Supreme Court.
Right.
In three cases, well, two right now. I think I kind of found my way through there and navigated all around all of their crap. And how many times have you heard when you state the law, you're not an attorney, you don't know the law?
That's called an inference. Now, an inference is basically a conclusion drawn from an observation or series of observations, right? That's an inference. It doesn't mean jack shit.
Well, again, the judge is not supposed to be there they're not a party to the case. They're the disinterested third party. They're supposed to be the umpire calling balls and strikes, findings of facts. Is it a fact that the Virginia Declaration of Rights from June 12, 1776 says that my right to a trial by a jury
this is the whole
is that a fact of law or not?
This goes into the whole
notice.
fallacy. It goes into the whole fallacy of our legal system.
Mm-hmm.
I shouldn't need to know the law. That's your freaking job. You know, it says in the canons of judicial conduct that a judge shall be knowledgeable in the law. It doesn't matter whether I know the law or not. I just need to present you the facts, and you need to decide according to the law. You know, and they come up with this crap in appellate court so many times. He didn't cite any supporting authority. I don't need to, you know, but I mean, in my personal cases, I cite the hell out of supporting authority. I bury it, and they still ignore it. But that happens. I mean, it doesn't happen to me, but I see it happen in a lot of pro se cases that I've researched. That they say, oh, he didn't cite any supporting authority. You know, don't you know the law? Why do I need to cite the law? You're supposed to know it. And this is a whole fallacy of these mock trials that we subject us to, you know, where they say, you don't know the law. I don't need to know the law. You're the one that needs to know the law.
Well, the problem is they want to try and say that their stare decisis is the law. They want to try and say that their policy is the law, their rules of procedure are the law, and that they're above the law. They have absolute immunity, and the Rutherford doctrine says so, and blah, 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 blah. No, you're just a man as like the rest of us, and you want to know what the actual law really is? The law of nature. How about something like thou shalt not murder? How about thou shalt not bear false witness? That's actual law. And that particular one is the ninth commandment. And that one is codified as the law as perjury. We all understand and see how that works. Right. The ninth commandment says thou shalt not bear false witness, which means you can't lie. And in our form of government here, we codified that as perjury. Mm-hmm. But the ninth commandment is the law. The code is not the code. It's codifying the law.
Right. So basically, well, let's go back to the Miranda warnings, because this is a simple one. If you're taken into custody and you're not read your Miranda warnings, you file what's called a motion in limine. Now, what's a motion in limine? A motion in limine is a motion to exclude or admit evidence often made before trial and usually heard out of the presence of the jury. Right. So
it's a pretrial motion.
Exactly. So what you're going to say is well, I was taken into custody, but I wasn't read my Miranda rights. Where do I put that? The answer is what's called a motion in limine. Right. So you can basically state they didn't read the Miranda rights. The arrest is invalid. Bye. Everything. Yep. That's where the falsus in uno doctrine or fruit of the poisonous tree doctrine comes in. Everything they obtained after that moment where they trespassed, the motion in limine, that time frame, they can't use against you anymore. So I don't care if they found an open container in your car and they know it. As soon as they find that open container, they have to Mirandize you. And I know that because it's in the freaking book, because I studied the book. So, you know.
This is a post that Amy Calling just posted right now. The family court judge said everybody lies. It's okay for everyone in court to lie and commit perjury. And that's, you know, attorneys and judges love perjury.
Right.
It generates billable hours. You know, the victim of the perjury is going to fight tooth and nail to come back and prove the perjury false. You know they're coming back. These guys love the perjury, and I'm bringing it to the Tennessee Supreme Court in another case I've got open right now. Does it lead to chaos in the courts when the states refuse to enforce perjury statutes? And as a victim of perjury, is my right of equal protection under the law being violated? And I don't care how they rule, because it's win-win for me, and I hope they're watching, because that's going to be another cause of action for me. Mm-hmm. So, you know, I'm okay with however they rule on that one, but that is one of the root problems in state court proceedings right now, is that perjury statutes are not enforced. If they were, half of this crap wouldn't be happening, you know? Right. And these guys just love it. They let it go right along, you know? Right. and they don't sanction them. I mean, you know, if it's material perjury in Tennessee, it's a felony crime,
right?
You know, and if it's not material, it's still a misdemeanor. But in any case, it's certainly sanctionable. And they just look the other way. They don't do anything. They don't care because they like perjury.
And, you know, here's one of the reasons why I believe they want me to take out these bad actors here. Even in the proceeding, there were a few people that had actually called into what's called appear by phone. And the only way that the court would allow them to appear is if they had a notary to swear them in, right? Now, a notary is an officer of the court who does have special emolument privilege, right, to bear witness or to administer the oath of, do you swear to tell the truth, the whole truth, nothing but the truth, so help you God, blah, 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 blah. And here's my notary number, GG 154 748. They were duly served notice of this. They had it before court. So when I sat there and I watched this jerk sit there and literally commit multiple acts of illegal searches and seizures right there in the courtroom, he made one guy open his wallet and pull all those cash out of his wallet. He told one guy, now this guy was, he definitely qualified for ADA advocacy because he was disabled. And it didn't matter. As soon as it came out, this guy, you know, it came out that he was, you know, medically disabled. This freaking attorney or whoever the hell he was, he starts badgering the crap out of this guy. I mean, you know, he just pummeled him with irrelevant questions. You know, it was all I could do to not stand up and go, objection, irrelevant badgering of the witness. I mean, I'm just like,
stop.
It was all I could do to stay in the seat. Like, no, I know why I'm here. I know what I got to do. I have to bear witness to this shit, even though I don't want to. So, you know, believe me, it was just that day, that Monday, from the time I hit the door till the time we walked out of the courtroom door, that's logged right here. And I can tell you, I got notes on it and the whole thing. I mean, it was brutal, man. It was bad. Oh, God, it was bad.
Can I share a funny story with you guys? I think you'll really enjoy this. It's
right?
It's quite funny. So I work with this guy down in Arizona, talk to him quite a lot. And so he's got a litigant being subjected to a mock trial. And this guy does workshops and he helps people down there deal with this corruption and how to fight back. And, you know, the Arizona's constitution, like most constitutions, guarantees the right to trial by jury. So he's like, you know, in the group, he's like, so does anybody want to serve as jurists in this guy's case? And there, you know, several of them were like, yeah, I can show up. So he's going to bring his own jury in there. He is under Arizona Supreme Court rule. He's going to notify the court that they're going to videotape proceedings, and then when they walk in the courtroom and the tape is rolling, you know, the litigant's going to ask for trial by jury. And when the judge says you can't have one, he's going to say that's okay. We brought our own. They're here right now. You know, they can sit in the jury box or they can sit in the back. You know, we're okay wherever you want us. But the jury is going to decide this matter because this man has a right to a trial by jury. And I love how this guy is pushing them. And it's just like so in your face. And we'll see what happens. And it's win-win, you know, because either this guy gets a jury or we got like a really humdinger of a federal lawsuit going on there, I think.
So you ready for this? Okay. So I've kind of put this out there before, but these are all private corporation courts. These are no longer the people's courts. We're supposed to be in the common law courts. All of these courts are listed on Dun and Bradstreet. Every single piece, social services, okay? That, whatever they call it in your area, that's a private corporation. Your police department is a private corporation. Each and individual courthouse is a private corporation. I mean, we can get even crazy. The governor is a private corporation. The House of Representatives, the Senate, those are all individual corporations. Everything is all done by corporations. So,
Yep.
I mean, this is part of why, you know, we want to do bring us back to a Republican form of government, because we're not self-governed anymore.
Right.
I mean, it's part like admiralty jurisdiction with the equity scale, but you're going into like, it's like, let's say you work for McDonald's, but you're going to go over to Wendy's and get tried. Why would you be going to Wendy's to have a hearing between you and another party and have that Wendy's employee tell you whether or not you get this or you don't?
Right.
Where's the right to a trial by jury? You know, all these things that come around. It's much deeper than a lot of people are aware of.
Right.
It's seriously messed up.
Well, I mean, you know, and here's what it is. You know, you got so many people out there that they've become dependent, right?
Right.
On the handout, right? And that's what they wanted. They wanted everybody dependent on that handout. So, you know, the left hand doesn't have to tell the right hand what's going on, because they're saying, hey, look at the left hand over here. I've got all this stuff I'm going to give you. We're going to give you food stamps. We're going to give you a phone. We're going to give you this. We're going to give you. But don't pay attention to what's going on over here. Don't pay attention to that.
Yes, Daryl. It was the 14th Amendment that finally basically enslaved us all, and coupled with the birth certificate from 1910, the Social Security Act from 1933, and the bankruptcy. All of the bankruptcy is what really, because that's when the corporation, the United States, was created. We still have the United States of America. We still have the lowercase, the lower uppercase United States of America. There's like 3 different corporations under the United States. So every time that you enter into any of these contracts, your driver's license, your business license, your automobile insurance, your home insurance, everything is a contract.
Mm-hmm.
Article 1, Section 10, there shall be no law impairing the obligation of contracts. This is what everything has gone off of. Everything is that's why they don't like to uphold the Constitution. Half the time they won't even follow their own statutes.
Yeah.
As it is written. Okay. It's because of these contracts. Everything is about a contract. And, you know, I was reading earlier, acquiesce, okay? When you sign that document, you're acquiescing to the terms and conditions of the contract. And those terms and conditions, a lot of times, are listed in the statutes, whether it's the administrative code, you know, or wherever it is, whatever the contract is. Your driver's license, that's going to be in the transportation department section, which is a separate agency, right? The agency's policy is what you contracted into. Those are the terms and conditions of your driver's license.
Right.
Here's another point I wanted to make, kind of back on that other topic a little bit. Sorry to jump around on you guys, but you know, the emoluments clause, that no titles of nobility shall be granted. And you know, at the time that they were writing the Constitution, you know, everybody's like, why the hell do we need this? We're not going to grant titles of nobility. That's stupid. We already been through that crap with England, right? And so James Madison answered that question in Federalist 43. He said, but who can say what experiments may be produced by the caprice of particular states, or by the enterprise of, or by the ambition of enterprising leaders? Caprice of the states, ambition of enterprising leaders.
Right.
So he recognized, like, we don't know what's going to happen. And so I answered that question in my federal pleadings. I said, today we have an answer. And instead of lords and princes and kings, we have judges and esquires who are granted unconstitutional immunity and who are granted emolument and special privilege against us. We saw this crap coming 200 years ago, and we protected ourselves for it. And the federal courts still seem to want to enforce the federal Constitution. Astounds me.
Right.
We're going to find out if 250,000 people can go into the
question out there. What is a good book to read?
1984 by George Orwell. And he just
In
brought
their
it
own
up.
words.
It's in the group.
In their own words. This is a really great book.
Which one is it?
This was the third edition. A resource book, extracts from the federal and state authorities establishing the jurisdictional authority of the federal and state governments with special attention to sovereignty, citizenship, federal taxation, and remedies for the innocent.
That's right.
This book is loaded with all sorts of good stuff.
Mm-hmm.
It's just nothing but case law, really.
Right.
American Jurisprudence, Corpus Juris Secundum, Black's Law Dictionary.
It's funny because
here's the binding nature of regulations.
Yeah. We talk about what our rights of redress are, right? And it's one of the laws that I've chosen was Lex Scribonia, which is the law of the late Republic, abolishing the acquisition of predial servitudes through prescription, which is all of that contract shit, right? And there's basically a maximum law in here that stipulates something about let a person act in their own profession or something to that effect. I'll find it here in a second.
Hale versus Hinkle?
No, it's actually a maxim of law.
Mm.
Here's one for you, John. You talk about court. Speaking of, judges with their statute that says that they're allowed to bill you for attorney's fees if you sue them and you lose.
At market rate.
Yeah. No one shall take advantage of his own wrong. Right? That's a maxim of law. So, the origin of the thing. This is the best interpretation.
This book is just.
Yeah, here's another one. He who, under the cloak of the law, acts unjustly should bear double punishment. There's a maxim of law that I think pretty much will get the attention of a few people out there. Let's see, possessor. That I don't have his in front of me here.
Daryl Wayne knows a lot of philosophers and some good history too.
Mm-hmm.
We need to talk sometime, Daryl.
I love Socrates. He's so awesome. What? No comment there?
Yeah, I've been watching the feed. He's been dropping a lot of good stuff in there.
I made it funny and called him Socrates. It's Socrates, but nobody caught it.
Yeah. Anyway, okay, I just found it. Basically, what it says is, let everyone employ himself in what he knows. Right? That's actually a maxim of law. So when I said, you know what, I'm going to take and retest my fiduciary license. Right? It's a credential that I earned. Here's the maxim of law that's a maxim of law that I assigned to my right to do that. Right?
You have the right to contract your labor as you see fit.
Yeah. And you know what? As far as I'm concerned, this quit being about me, what, 7 or 8 years ago? You know, this was more about, you know, my kids and the effects and the negative effects of the shitstorm they're going to suffer, and they don't even know it's coming.
There's another maxim out there too, that you're entitled to the entire fruits of your labor.
Yeah. Well, you know, we'll worry about the fruits of labor later on. Right now, let's finish the project, right?
Right.
And the project for my involvement is the emoluments clause itself. And it's time after 230 years to practice that sucker in accordance with American jurisprudence, not these, you know, these statutes, codes, rules, and regulations, which are not law, right? We're going to start practicing the true law, okay? The law that was intended as it was written.
The law of nature?
Yeah. So, you know, Monday when I dropped in Trump's proclamation on them that basically, hey, we're going back to the rule of law, Bubba. Take your statutes, codes, rules, regulations, and guidance documents and drop them suckers in the shredder because those bastards no longer apply. You're done. And, you know, that's why I said dude was like red as your hat pissed, man. Oh, he was pissed. But, you know.
You know, I actually finished up writing that response to a motion in limine last night about 1 o'clock. I'll have to send that over to you and see what you think.
Mm-hmm. Is that your motion in limine, or are you responding to their motion in limine?
Responding to their motion, and it's not my case, but
right,
helping a brother out.
So Dean asked, why keep talking about laws and maxims that are not even followed? The reason they're not followed is because nobody's talking about them.
Right.
Bingo. Back to what Daryl was saying. We say what the law is, and that is true. That's what lawyer means. The law sayer, the one that brings the law. You are the one that is knowledgeable on the law. This is why ignorance of the law is no excuse.
Right.
But back to like what John was talking about, they're the ones that are deemed to know the law. If you say, hey, this person over here ran over my foot with their car, they're supposed to know what law is that protects me from that kind of injury. Well, did they willfully do it? Well, yeah, they swerved over at me. Well, they did it with malice. Maybe they were, some elements of the crime there, that part of that elements of jurisdiction, findings of facts, willfulness with malice, premeditated, those kind of things.
But there's also, too, when you talk about where legal maxims come from, I talked about this a little while ago. There are, speaking of legal maxims, there's one that says, where there is society, there is law. Okay. These are fundamental principles of practice. Okay. Remember the difference between the theory and the practice. Everybody's so focused on the theory. Nobody's focused on the practice. That's where I work. I work over in the practice. I'm like, I know what it says. You don't got to tell me what it says. I've got, book upon book upon book that tell me what it says.
John's like that over there in the Supreme Court.
Right. I'm talking about the fundamental principles of practice. Those are the maxims. Yeah. Okay. So when you talk about things that govern your behavior, right? Right. Good faith. Where does good faith come from? That does not come from the Black's Law Dictionary. That doesn't come, that comes from, in our ideology, the Bible. So,
and I want to bring up another point on this, because I think that's a really important point that gentleman made.
Yeah, you're right.
Why talk about this stuff if they're not going to follow it?
Right.
Here's the thing. You guys got to realize that we're subjected to mock trials, right? Everybody agrees, right? Okay. Why do we have mock trials? Why not just, when litigation is filed why don't they just take all of our money and all of our property and not go through that mock trial process? Chris, why do we have the mock trials?
Well, they have to show something, right?
Yeah,
because they know they can't do that.
Yeah, it's the appearance of due process, right?
Right.
That's what they're doing. So what does that mean? What does that mean? If they have to present an appearance of due process, that means they still got to give due process in my mind. And so when you learn the law and you know their stupid rules that they've created to complicate this process, to confound this process, when you learn their laws and their rules and their guidance documents and you back them up against the wall, that's how we defeat them. I have certainly accomplished that going up against some of the most corrupt judges out there, I think, or certainly judges that are under the influence and most certainly are heavily biased. Perhaps they're corrupt. But I've done that by knowing the rules, knowing the laws, and saying, you know, are you going to follow them or not?
Right.
Because they have to give the appearance of due process. When you force them, they have no choice. And that's what I intend to do in my cases. And that's what we intend to do as a group, we the people against the 50 United States, is we're going to go in and say, you know, here's the law. We're demanding due process. Are you going to follow it or not?
Right.
Are you going to commit treason?
Paragraph 2. What you just talked about is going to take me to paragraph 2. We still didn't get through the report. So that's actually in paragraph 2. This can be evidenced in the casework in the federal Article 3 courts as it relates to the lower state equity courts. In state equity courts, the proceedings, decisions are made and the documents are prepared before entering into the courtroom. The hearings are merely to present the appearance of due process as a means of creating billable hours, not actual due process itself, as in most of these state cases, unbeknownst to at least one party, as that party has been either betrayed by counsel or is unrepresented by counsel. It is this problem that generates the Dear Colleague letter from the U.S. Department of Justice, on which much of my work is based. Upon closer review of the cases cited within that letter, I soon came to realize this problem in these lower state equity courts was an epidemic caused by the practices to which I am referring. Confirmation of this can be found at the top of the letter, as it reads as follows: U.S. Department of Justice, Civil Rights Division, Office for Access to Justice. Now, why was that important? The reason that was important because, remember, in the preface, I said the intention here is to equalize the practice of law as it was intended, right? Through the State Department, which most states don't even have as Department of State. So who's there to provide for the common defense? And the answer is nobody. That's the problem. That's the deficiency, the bone, and the reason why that it's not there, and the reason why these states are not Republican in character or form, like John says. So, this is why I said this is where, where our work starts to kind of overlap a little bit. And, why when we put this team of people together, we decided to pick our strengths and go at this based on, what our individual strengths are. Mine is in practice. John's is, also in practice, but he's more into actually learning their rules, which personally I don't care about, because their rules are, as they're written, aren't law, and they actually violate the law, right? So, and that's kind of my point, and why John and I work well together as far as how that works out. Kirk's involvement with his knowledge of the law itself is major key, because he kind of bridges the gap between me and John when it's like, where was that in law? Kirk's like rattles that shit off like right there. Oh, right over here. It's like, oh, that's right. Okay.
This is what makes such a great team.
I want to hit Francesca's comment. Francesca said, what about when they're so corrupt and retaliating when we're and it's at the higher level. The trial courts, they can do whatever the hell they want, and 99.9999% of the time they're going to get away with it. That's why they do it. But when you get to the appellate and the Supreme Court level, they got to follow the laws. So there's nothing you can do at it. So what do you do when they're doing that, Francesca? You're in evidence gathering mode. That's what you're doing.
About that, Kirk?
Exactly.
What do we say about that? What are you there to do in the district court?
You are there to make your record.
Correct. Okay?
Get your paperwork filed in the record.
Yeah.
And make sure that paperwork that you file is, that you've telling them who you are, that special appearance, or just a general appearance if you're going to battle it out.
Right.
Special appearance if you're objecting to the jurisdiction.
Mm-hmm. Yeah, I never complained. I never complained with, when my rights were being violated, I never stomped my feet. I never got angry. Nope. Same demeanor that I always am, but I handled it when I got into a higher level court,
Right. Now it's game on. Now that we're in higher level court.
Back to what we were talking about there is the in the record and then on the record. Mm-hmm. Okay. So when we file our appeals and we do the motion for the transcripts and it goes to the appellate court, okay, that's what they look at. The appellate court only reads the transcripts. They don't care about what you think, how you feel, okay? It's the arguments that you made on the record. And so when you file the paperwork, that gets you the ability to be heard. Back to what we've talked about before is, we were taught in grade school to raise our hand in order to be heard. This is what you have to do, what we have to do to be heard in court. Yeah. And, something to put in your mind, folks, here is when you go to court,
there's a couple
everything else that's around you. Grab your paperwork, all the paperwork you filed, and you read it. Make your statements, affidavits, okay? That's a good thing to do. Affidavits signed under penalty of perjury and notarize.
Yeah. And that is exactly, and that plays right into some comments that were just made there. What if they're denying you entry into the record? What if they're not letting you enter your evidence? And so what I did is I just started writing memorandums of law, mm-hmm. and then I would say, here's the facts, and here's the evidence supporting my facts. And I sign an affidavit saying, I affirm and hereby swear as true everything that is included in this document. And then I take it in and I get a file stamp, and I get the exhibits file stamp as well. And now I've got it in the record, and I was able to use that in appellate court. The trial court would, I'd say, I'd like to present this evidence, and they'd come up with, some bull crap, lack of foundation or whatever. And they would deny me entry into the record of my evidence. So I learned that crap early on. And I'm like, okay, well, if you're not going to let me do it in the courtroom, I'm going to do it in the clerk's office. So if you're getting denied entry in the record in the courtroom, do it to the clerk's office, get a file stamp.
Right. And so some of the times, we talk about evidence. They won't let me enter my evidence. Well, the thing is sometimes the evidence isn't attached properly.
You just took the words right
on. I just recently found
right
is to put them on notice that they have to follow the strict standards of evidence.
Right.
Like kind of backwards, reverse practice again.
Yep. But you got to reverse that reverse.
Okay. So we have to put them here in Idaho. We have to put them on notice that we want them to follow the strict rules of evidence.
Right.
But again, attaching your evidence to your documents, you can't just go, I have this piece of evidence and I'm going to file it, and they won't let me file it. Okay. Where's your brief? Where's your memorandum? Where's your affidavit?
Right.
So a motion with an affidavit signed under penalty of perjury and notarized with your evidence attached is Exhibit 1. If you're the respondent or the defendant, at least here, it's 1, 2, 3 is exhibits. If you're the petitioner, then you're A, B, C, D. So
So basically, and one of the reasons why they're so pissed at me is because all of this was done and everything was on the record, not just in the court in this particular case, in my case. I've also entered it into the record in Congress, 14.82 pounds of paper. That's a lot of paper. So now, as far as calling special attention to evidence that's already in the record, what I did was I just went straight to the chase. I just created this general motion here, and this one was motion to proceed Article 3. And then the pieces of evidence that I made reference to that were on the record anyway, I attached new copies to it for the court's convenience. So right under my name where I signed with my credentials and everything, I put the word attachments, and there were 2. Presidential proclamation reestablishing the rule of law, and number 2, notice from the Mahoney County Sheriff or Mahoney County Child Support or Child Services, basically where there was no finding of abuse or neglect, and that all the allegations were unsubstantiated. They cleared my name. Numbnuts, what are we doing here? Was basically what I said to them.
Right.
And I said, here's what's not going to happen. You're not going to take 8 out of every $10 that I want to give to my kids, and they say, "Hey, Dad, I don't need $10. I want to go see a movie." Oh, here's 2 because I'm going to give the other 8 to the state, right?
Yeah.
I'm going to be a little more than slightly miffed about that. So, and I know they're young; they don't understand the process, and I get that, right? But the simple fact of the matter is, I have to handle that process first, and that's where I talk about the weaponized family court and how they've driven that wedge in there, and they've made me fight this frickin' process for the last 10 years and basically use the children as human shields in a judicial process. And that's what I'm going to argue in the Florida Supreme Court. That's going to be right there, right, like opening statement, right? You guys have figured out how to use children as human shields in the judicial process. So I'm going to let them have it, and I'm going to let them have it good. But yeah.
Okay,
right.
So
I've spent the last
5 minutes. We're at the 5-minute mark here. So I'll let everybody know. Thank you for tuning in. Like, follow, get the notification when we go live, and share Kirk's Law Corner. And if you want to get in with this here, obviously you're already here listening to this. So if you want to get in with the We the People versus the 50 United States, send us a message here, either John Gentry, Chris Hallett, myself, Kirk's Law Corner, wherever you can send us a message and tell us you want in there. We'll get you in there. It's growing like wildfire, holy smoke, it's growing faster than 2.5 foot tall weeds in my front yard right now.
Right.
So any last 1 minute stuff before we close this out tonight?
Just want to thank everybody for dropping by. Don't forget the rest of the week reschedule. We've got tomorrow night, Tuesday night, 8 p.m., Far From Normal radio show. Jay put out there in the comments, there's some real interesting guests going to be on the show. So drop in, say hi. Wednesday we'll be back. We've got some guest callers ourselves. They're going to be with us.
Yep.
Call-in show, and Sundays.
We have 2 lined up right now.
Yeah. So Sundays and Thursdays we've got Restoring Families Internet Radio and Blog Talk Radio. They have a bunch of different platforms, and a bunch of different people doing a lot of good things. So say hi to Amelia Duran. I love talking to her, talk to her regularly. And that's about it. Who I want to say hello to.
John?
You guys get, if you want to stand up to your rights, Kirk said it, we the people versus the 50 United States, we're going to demand reform in the United States Supreme Court, original jurisdiction case, and we intend to be heard. And so, it's time to start standing up, folks, and to get out and do something about this broken legal system. Thank you guys for taking time and watching the show tonight. God bless all of you. I hope to see you back Wednesday, and look forward to hearing from all of you.
Awesome. Thank you, brothers.
Thank you, Ted. Love having you there, brother.
Yeah, Ted.
Yep. Thanks to our producer over there, Ted Fogg. He makes all this magic happens even through all the technical difficulties.
Frickin' Facebook messing with us tonight.
Oh, it might have been partially my fault too, so hey, I'll take something right there.
Hey, well, hey.
Technical difficulties with computers and multi-streaming, and that's all Ted stuff over there. But anyway,
right. That's why we
love. Great job. He does. He really does.
That's
so
right.
We love you, Ted, and we love you out there, our friends and family out there. Whether you believe it or not, we love you all. We do care. That's why we're here.
Right.
I'm sorry that we can't drop everything we're doing and help people on an individual basis. Some people we do, some people we can't. But our main focus is trying to fix our nation as a whole. And what Chris is building is working towards that. What John's idea there is and what we're working on, what John's doing there is another avenue. This is another avenue, educating you at least on what your rights are, how to claim them, where they come from in law makes a big difference, because if you can quote it, well, yeah, Virginia Declaration of Rights, June 12, 1776 says, I have this right here, as it is written in black and white. That's what it says. So that's what we're doing. We're trying to help. We're doing what we can.
One just last little quick comment on what Kirk said. The stuff that we're working on has not been tried. We don't know how it's going to work out, but we're going to give it one hell of a shot. And if you don't try, you don't know. So we're gonna give it a try and try to make this happen. I can tell you it's different, and we know the other things that have failed. We're well aware of all the attempts that have been made out there. We're trying something different, So we hope you guys will join with us and stay tuned.
A comment that Chris made when I first met him is like, well, we're just going to throw some stuff out there and see what sticks. So, it's better than sitting at home doing nothing and ignoring what's actually happening out there, that families are being destroyed. And again, I want to reaffirm this, people. It's not just the family courts. It's the whole entire thing. Everything.
Top to bottom.
Yep.
Top to bottom. This
legislative branch, executive branch, judicial branch, agencies, everything.
Mm-hmm. So,
all right, guys.
All been an usurpation.
Love you guys.
Coup d'etat from the War of 1812.
Yep.
Much love. Thank you,
Betcha.
brothers, sisters. Thanks for tuning in, sharing.
Bye, guys.
Let's get in that group. Let's get some numbers going. It's growing like a wildfire right now. Thank you very much.
Yeah.